Hi, this is Scott, maybe, and I'm talking about contract law as it refers to the area of purchasing or supply management. So there are various requirements for a contract to actually exist. So it's not as simple as simply writing up a contract with a supplier, negotiating and agreeing on terms, and believing that that actually is a contract in the eyes of the law. There are several conditions that need to be met. And the first one would be an acceptance of an offer. And this sounds simple, but actually we need to verify what the offer actually is and whether in reality the offer was actually accepted or not. And sometimes that can be more difficult than it might seem to be intuitively. So an offer is a proposal or expression by one person that he or she is willing to do something for certain terms. And it has to be clearly expressed. It can be in writing or it can be verbally. But the offer doesn't exist by itself without being considered a contract in the eyes of the law. There has to be clear acceptance of that offer. So the contract doesn't exist until the offer is formally accepted, either verbally or written. And this has to be a meeting of the minds, meaning that both people actually have to be confirming with the other that there's been an acceptance of the offer. It may provide differing terms and conditions from the original offer. So the acceptance of the offer can be in the form of a counteroffer, and then that counteroffer is accepted by the original source of the offer. But clearly there has to be an offer and acceptance of the offer. So acceptance can be any manner by any medium. It can be through the promise of acceptance. So in other words, I promise to accept your offer at a certain date in time. It can be by the supplier's performance of terms and conditions of the contract. So the acceptance of the offer can actually occur based off actions by the supplier or the seller or the buyer. The terms of the purchase order versus terms on order acknowledgement can be an acceptance. So for example, the terms of a purchase order that I place as a buyer and send to a seller, the order acknowledgement from the seller may change the terms and conditions of the purchase order. But as a buyer, if I don't challenge those changes to the terms and I accept the order, that's acceptance of the order. So be careful as a buyer with ensuring that the order acknowledgement from the seller doesn't have terms that are different from your original purchase order. And that's something that would be the due diligence of the buyer to ensure that that the order acknowledgement and the purchase order matches. So always review the supplier's acceptance documents. If there is a discrepancy, it should be challenged and considered a counteroffer to your original offer, which is the purchase order. And therefore, you must not accept the offer if you don't agree with the terms that have been changed from the original purchase order. So let's try a few examples. A supplier sends an offer to a buyer by email. The buyer does not respond. The supplier ships the product to the buyer with an invoice. What was the offer? So the first thing we need to determine in all of these examples is what was the offer? And then the next question is, was the offer actually accepted? Pause the video and consider the facts above and try to answer the questions as best you can. So the first question is, what was the offer? The offer was whatever the seller sent to the buyer by email. And that would mean that that offer was indeed in writing. So was the offer accepted? Well, let's look at the facts. The buyer does not respond to the email. And then the supplier ships the product to the buyer with an invoice. So was the offer accepted? No, the buyer didn't respond. And even though the supplier shipped the product to the buyer with an invoice, it doesn't mean the offer was actually accepted, since the buyer didn't accept the product into their inventory or pay the invoice. So in this case, The offer came from the supplier, but it was not accepted. A buyer sends a purchase order to a supplier for 200 units at $20 per unit. The supplier confirms the purchase order. The supplier ships 200 units to the buyer with an invoice stating the units are priced at $30 per unit. What was the offer? And was the offer accepted? Pause the video and consider the above information to answer the questions to the best of your ability. What was the offer? The offer was the purchase order sent from the buyer to the supplier for 200 units at $20 per unit. Was the offer accepted? The supplier did confirm the purchase order with the buyer. So the offer was, in fact, accepted. The fact that the supplier shipped 200 units, invoicing at a price of $30 per unit, is a discrepancy between what was sent to the buyer and what the buyer originally offered in terms of the purchase order that was accepted by the supplier. So in this case, the offer of $20 per unit and 200 units was confirmed by the buyer, by the seller. So the fact that they've shipped 200 units at a different price is irrelevant, and the supplier would need to honor their original confirmation of the terms of 200 units at $20 per unit. A supplier reviews an RFQ sent from the buyer. At a charity gala, the supplier is reminded about the RFQ and verbally confirms with the buyer their price over a dinner conversation, writing it on the back of a business card they hand to the buyer. What was the offer, and was the offer accepted? Pause the video and review the facts above to answer the questions to the best of your ability. What was the offer? The offer was the RFQ sent from the buyer, not the price being supplied by the supplier. So the original offer was the offer to bid on an RFQ. Now, was the offer accepted? Well, at the charity gala, the supplier is reminded about the RFQ and verbally confirms their price with the buyer. Regardless of the situation, the supplier accepted the request for quotation and provided their quote. So the offer to bid was accepted from the supplier. And the fact that they've written it on the back of a business card that they handed to the buyer is irrelevant. The price that they've confirmed with the buyer would be the price that they would have agreed to in the bid. So what are the ramifications of this? Well, if a supplier won the RFQ contest and was awarded the contract, the supplier would likely challenge the buyer because of the nature of how the quotation was submitted. However, as we know, an offer and acceptance of an offer can be verbal or written. And the fact that it's written crudely on a business card is irrelevant. The fact remains that the buyer offered the seller to provide a quote, and the seller confirmed the quote. So whatever happens after the fact cannot be changed based on the original offer and acceptance of the offer with a quote that was crudely written on the back of a business card. So the offer was accepted by the seller. So we have offer and acceptance, but we also have another requirement in order for the contract to be formed in the eyes of the law. So the second requirement is consideration. Consideration is something of value in the formation of a contract that gives it some sort of legal validity. So it's something of value, usually in the form of money. Or it could be it's a form of mutual obligation. There needs to be a goods or services provided on behalf of the seller that are exchanged for in consideration of something that's given up of value from the buyer. So it's a willingness to give up something of value to another party. And there can be mutual promises granted from the buyer and the seller that are either expressed or implied in this case. So let's take an example of a classic consideration question. There are two different quotes on this slide. One is coming from the buyer and one is coming from the seller. So the first is, I will agree to paint your house with white paint for $100. Is that coming from the buyer or the seller? Well, this is coming from the seller. I will agree to paint your house with white paint for $100 is clearly coming from the service provider, not the buyer. Let's read the next quote. If you paint my house with white paint, I will pay you $100. Is this coming from the buyer or the seller? Clearly, this quote is coming from the buyer, meaning that there is an offer and it has been granted from the buyer in the bottom example and in the top from the seller. So the source of the offer is from the buyer or the seller. The question then is there a difference between these two statements? And this is a consideration question. Pause the video and consider the two and think through, is there any difference you can see in these two statements? Or are they saying exactly the same thing? Is there a difference between these two? At first glance, it seems that they are identical. I will agree to paint your house with white paint for $100, or in other words, I will agree to paint your house with white paint in consideration of $100, versus if you paint my house with white paint, I will pay you $100. Or in other words, I will pay you $100 in consideration for you painting my house with white paint. So at first glance, these seem like identical statements. However, the consideration remains the same, the $100, but it is the condition of what is for consideration or what is under consideration that can make differences in the contract itself and the implication of the contract. So if we look at the first statement coming from the seller, the offer coming from the seller, the service in consideration of money, the seller is saying, I agree to paint your house with white paint for $100. However, the bottom statement says, if you paint my house with white paint, I will pay you $100 in consideration of the task being completed. The first does not say that. So the first statement is ambiguous. It does not specify at what point the buyer must pay the seller the $100. And it in fact implies the agreement to paint the house alone is enough to warrant the buyer paying the $100 to the seller. It's clarified in the second statement that the agreement to paint the house alone is not enough to warrant consideration of $100. In fact, the seller must paint the house with white paint in full to receive the $100 in consideration of the service. So the two do appear to be the same, but in reality, they have significant differences in terms of the contractual obligations between the buyer and the seller in consideration of that $100. So be careful with contracts and the wording of contracts and what the implications of the contracts can be when you're dealing with things like consideration, giving up something of value in order to receive something else of value. The third requirement is that the contract must have competent parties and mutual assent. So competent parties means that both parties must be competent. They must be qualified to engage in the contract. So they must be a qualified agent. If there are licenses that are required, such as a real estate license, they must have that license. They must be registered to be able to actually engage in negotiations and to act as an agent in the eyes of the law. So either the principal must be either principal or a qualified agent to arrange contracts. They must have not engaged in any fraudulent activities when formulating the agreement. That would be another form of competency. And then when it comes to mutual assent, they must act in their own free will. There must be no force or coercion. So mutual assent, meaning that both the buyer and the seller must engage in the contractual arrangements freely without any force or coercion of any kind. And a willingness to enter the agreement and be bound by its terms because both believe that they would benefit from the contract itself. So let's look at a few examples here to practice applying these principles of competency and mutual assent. The buyer tells the seller if they don't sign the contract, the buyer will make some phone calls, implying that the buyer will use their network to compromise the seller's business. Are both parties competent? And I would also add, is there mutual assent? Pause the video and consider the facts above and try to answer the question to your best ability. Well, because both parties in this case are not exercising mutual assent, then we could argue that both parties are not competent. Because the buyer is using coercion or duress to force the seller to sign the contract against their own free will. So in this case, parties are not competent because there isn't mutual assent. A seller is drunk at a dinner gala event and signs a contract with the buyer to sell their company services to a buyer at half price. Are both parties competent? Pause the video and consider the facts above to answer the question. Are both parties competent? Clearly not. The seller is drunk, meaning that they are not sound of mind. And this is one example of competency. So when you're dealing with buyers and sellers who may be mentally challenged or compromised because of drug or alcohol, then that means that you are not competent to engage in contractual arrangements. So even though the seller was drunk and signs a contract with the buyer, the seller could argue that they weren't competent at the time they signed the contract, and therefore there's, in the eyes of the law, there is no contract. It's always best, however, to not sign contracts if you're under the influence of any substance. Okay, so that's a third requirement. Another requirement is that there has to be legal subject matter. So the product or service that is being sold must be legal. If it's not legal, then even if the contract has an offer, an acceptance of an offer, even if there's consideration, and even if there's mutual assent and competent parties, if the subject matter itself is not legal, such as drugs, then, or illegal drugs, then of course the contract is null and void. The performance of party may not be unlawful to be enforceable. And if the contract is lawful, but some terms aren't, the unlawful contract terms are thrown out, but the contract itself may still remain. So the contract, depending on the legal subject matter, some of the contract may be unlawful, and then that would just simply be null and void, but the contract itself could still remain in the eyes of the law. So let's look at an example of legal subject matter. The buyer for Best Buy, which is a retailer that sells electronic goods, sends a purchase order for Apple iPhones to Apple, which Apple ships in full. Apple adds a clause insisting that Best Buy must sell the iPhones at a specific price. This is against Canadian competition laws. So is the contract lawful? Pause the video and consider the question. Is the contract lawful? Well, after reviewing the details of this case, we can see that the buyer for Best Buy sends a purchase order for Apple iPhones to Apple, and then Apple accepts the offer and ships in full. So there's nothing illegal here with the contract to buy iPhones from Apple. Apple adds a clause, however, to the contract that insists that Best Buy must sell the iPhones at a price that is against Canadian competition laws. So we know that that is an unlawful part of the contract. Is the contract fully unlawful and therefore void? We could argue that, in fact, the contract is lawful. A portion of the contract is lawful. There's nothing illegal with buying iPhones from Apple and selling them as a retailer. But what is illegal is Apple trying to force the buyer to sell at a specific price that goes against Canadian laws. So that portion of the contract would be considered unlawful and therefore not enforceable. But the contract would likely still remain in place. Just portions of it are unlawful and therefore would be null and void. Now, boilerplate terms and conditions are also added to many contracts. These are just standard terms and conditions. Usually they're pre-printed on the back of forms. They're very standardized. So if you've ever bought a product or a service, such as a cell phone, oftentimes the service provider will have a booklet of boilerplate terms and conditions that every client gets. When you're a buyer, it really matters what these boilerplate terms and conditions say. As a buyer, as a consumer, oftentimes we don't even bother reading these. But as a buyer in a professional organization, it's very important that we understand what the boilerplate terms and conditions are. Never assume that the terms and conditions don't apply to you or are not meaningful, or that you understand what the terms are. Have a lawyer review these if you're not sure. Never make any assumptions as a professional supply manager. If you don't agree with terms, you should challenge any terms in writing that you don't want to accept. And if in doubt, don't sign anything. So this is explaining the elements of what makes up a contract in the eyes of the law.